Welcome back to our daily news update, bringing you the latest headlines from around the world. Now let's begin. Supreme Court rejects affirmative action in ruling on universities using race in admissions decisions. In 6-3 affirmative action opinion, Supreme Court decides using race as factor in college admissions violates Constitution's 14th Amendment. The U.S. Supreme Court handed down a major ruling on affirmative action Thursday, rejecting the use of race as a factor in college admissions as a violation of the 14th Amendment's Equal Protection Clause. In a 6-3 decision, Chief Justice John Roberts wrote in the majority opinion that a benefit to a student who overcame racial discrimination, for example, must be tied to that student's courage and determination, or a benefit to a student whose heritage or culture motivated him or her to assume a leadership role or attain a particular goal must be tied to that student's unique ability to contribute to the university. In other words, the student must be treated based on his or her experiences as an individual, not on the basis of race. The opinion reads, many universities have for too long done just the opposite. And in doing so, they have concluded, wrongly, that the touchstone of an individual's identity is not challenges bested, skills built, or lessons learned but the color of their skin. Our constitutional history does not tolerate that choice, the opinion states. Justice Roberts was joined by Justices Clarence Thomas, Samuel Alito, Neil Gorsuch, Brett Kavanaugh and Amy Coney Barrett. Justice Sonia Sotomayor wrote the main dissent, joined by Justices Elena Kagan and in part by Justice Ketanji Brown Jackson, who recused herself from the Harvard case due to her previous role on Harvard's Board of Overseers. Many universities have argued that race-based admissions ensures that student bodies remain diverse, while critics such as the plaintiffs in the cases argue the policy discriminates against many qualified students based on race. Students for Fair Admissions, a student activist group, brought cases against both Harvard and University of North Carolina. The group initially sued Harvard College in 2014 for violating Title VI of the Civil Rights Act, which prohibits discrimination on the basis of race, color, or national origin in any program or activity that receives federal funds or other federal financial assistance. The complaint against Harvard alleged that the school's practices penalized Asian American students, and that they failed to employ race-neutral practices. The North Carolina case raised the issue of whether the university could reject the use of non-race-based practices without showing that they would bring down the school's academic quality or negatively impact the benefits gained from campus diversity. The U.S. Court of Appeals for the First Circuit had ruled in Harvard's favor, upholding the outcome of a district court bench trial. The district court said that the evidence against Harvard was inconclusive and that the observed discrimination affected only a small pool of Asian American students. It ruled that SFFA did not have standing in the case. In the UNC case, a federal district court ruled in the school's favor, saying that its admissions practices withstood strict scrutiny. The affirmative action cases gave rise to one of the most spirited court debates to occur within the Supreme Court building this past term, with Chief Justice John Roberts and Justice Samuel Alito grilling Harvard's lawyer, Seth Waxman. Alito pressed Waxman on why it is that Asian American students regularly receive lower personal scores on their applications than other races. Waxman talked around the justice's questions, causing Alito to get frustrated with the lawyer. I still haven't heard any explanation for the disparity between the personal scores that are given to Asians, Alito said. Waxman then got into a tense back-and-forth with Roberts. The justice asked why Waxman was downplaying race as a factor in admissions decisions, when according to Roberts it must have some impact or else it would not be included. Waxman admitted that race was decisive for some highly qualified applicants, just like being an oboe player in a year in which the Harvard-Radcliffe Orchestra needs an oboe player. We did not fight a civil war about oboe players, Roberts shot back. We did fight a civil war to eliminate racial discrimination. Subscribe to my YouTube news channel now, providing accurate and reliable information on the latest hot events. Join the community for exchanging opinions and learning from each other. Hit the subscribe button and turn on notifications to never miss out on the latest videos. Let's explore the world of information together.